Hello, this is a very interesting probate case dealing with a trust and a fight between, guess what, brothers and sister. And I think really the parents set this up poorly. Of course, that's after the fact. But what happened was mom created a living trust, revocable living trust. This is a very common estate planning tool that we use for clients all the time. You may have one, or your folks may have one, but it's a good mechanism to manage your affairs after you've passed away. So a lot of times we create a trust and it goes down between the bloodline, of course, and there's a provision for a brother and another provision for a sister, which is what happened here. Both of them had their own trust share after mom died. What was interesting and created the lawsuit was that mom's trust says, look, if my son is married when this takes effect, he gets nothing. It goes to his sister. If he's not married, he gets his inheritance. Now, seems like an odd scenario. A lot of times we might write into a trust that in order to receive their share, or if the person gets married later, that they have to have a prenup or something like that to guarantee that the adult child's share goes down to them and doesn't get lost in a divorce later on down the road. But to say you don't get your inheritance if you're married seems very odd and problematic. Maybe mom didn't like the wife or whatever. Something was going on because the son had been married for 20 years. So you thought, well, maybe he was trying to do something, they were trying to prevent a problem, but it was a 20-year marriage. So the Court of Appeals decided that this was improper, that a parent cannot require a person to get married or not be married, to get divorced or not get divorced. You can't do that. It's against public policy. You can't write a contract that way. And as a son, he can't waive his rights under that provision later on in the trust. So the Court of Appeals said, no, the son can't be forced to divorce his wife of 20 years in order to get his inheritance. That's just void for public policy. So he gets his half and his sister gets her half. So if you're thinking about creating a trust, it's definitely a great tool, and it's an appropriate tool, but you got to be careful how you write it. And I'm curious what was going through the lawyer's mind when mom came in and said, I want him to have an inheritance, but not if he's married to you-know-who. So that seems just so kind of crazy. But it was reversed by the Court of Appeals. You can't do that. Let us know if you've got some estate planning questions. We do quite a bit of this work for clients, and we're happy to provide this information to you. And again, it's a war of the roses type of sibling rivalries going on. Our trust and our estate planning needs to be written in a way that creates peace, not fights in the family, right? So let's try to create peace in our families, not further arguments. That's it. Thank you so much, everyone.